Good afternoon, everybody. This is Brent Filbert. I'm the director of the Veterans Law Clinic here at Mizzou at the law school. I want to welcome everybody to our annual. We call it our Veterans Day CLE because we usually have it right around Veterans Day or on Veterans Day. But this year, because of the holiday and also numerous other things going on, we pushed it back to this week. But the um, the purpose of this CLE is to obviously is to educate lawyers and others on veterans law and how to represent veterans. So we're happy to do that. We also, and you'll hear more about this later on as well. We also want to really encourage attorneys to think about taking on veterans in VA disability compensation cases on a pro bono basis. That's one of the primary reasons that we do this. So welcome everybody. It's going to be a information-packed next few hours. And I'll leave it there for now. I'm going to do some of the training a little bit later, but I'll turn it over to Hannah Eastland, one of our staff attorneys and the person really running the show today. Hannah?
Thanks, Brent. I just want to cover a couple little items of administration for you. This is worth CLE credits, but it's also going to satisfy the accreditation requirements through the VA. And if you have any questions, because we have so many attendees, go ahead and just use the Q&A function through the webinar, and I'll be reading those out at the end of each individual section. We'll have a presenter cover a section, and then we'll get through any questions that were put in the chat immediately after, and then we'll go on from there. This is our itinerary for today. We're going to have one of our students talk about the Veterans Clinic, and then we'll cover each of the required sections for VA accreditation, and then I'll give a little spiel about our pro bono program for anyone who's interested. With that, I'll hand it over to Braden, who's one of our law students here at the clinic this semester.
Thank you very much, Hannah. To start out, I would like to take you back to a long last time, 2014, where I was still in middle school. And as a passion project, two students ended up approaching Professor Angela Drake there, who had never practiced anything in veterans law previously. And they approached her with the idea of starting a clinic here to be able to represent veterans pro bono, completely not for profit, out of the university. These students eventually ended up starting this small law firm in the school where students who take the course work under the supervision of a supervising attorney to help conduct intake interviews, develop client files, write legal briefs, and experience advocacy firsthand while in school still. Next slide. This model has grown year over year. In the past 11 years, the clinic has helped over 2,000 veterans and usually about 150 to 180 clients at any single time. Aside from just direct legal services, the clinic has several programs that broaden the impact that we can achieve. We will go over a couple of those here soon. The asterisk next to 21 million is there because the only number that we can actually measure is the retroactive payments, the payments that are received as back pay on the VA mistakenly denying or because we put in an intent to file at some time previously. And there's plenty other benefits that they get, though, the free health care, or even the non-monetary benefits of having their service recognized and not having their DD 214 show something other than an honorable discharge. Next slide. We hold outreach events and in-person intake interviews throughout the state as part of our Tiger for Troops program. I actually had the opportunity to go there recently down in Cape Girardeau. That's actually, I believe, from the most recent one. That is two of my clinic mates, Joe Grampo and Kayla Reese, and along with Professor Filbert, who was just speaking. We try to target counties with few or no veteran service officers available, so there's very few people to actually help them out there. This last one in Cape Girardeau, I met a couple veterans who were incredibly knowledgeable and on their situation and had been going through these situations for so long without any help. And it was just really nice to be able to even just give a small bit of advice, even if we couldn't end up taking on their files. And though we did take on a couple, and those people hopefully will be receiving the best help they can. The next one that we have will be upcoming in Rolla in February, and we table at various veterans benefits fairs and public events as well. Next slide. We also have the Show Me Hope program. This program allows us to prioritize veterans who are homeless or at risk of homelessness. We've taken on 44 clients so far. All of them are now housed. This is funded by a Department of Veteran Affairs grant. We're in the third cycle of that grant, and the program's going very strong. Uh, Currently is led by our licensed clinical social worker, Andy Rogers, who is great. And she spent several years working with the VA healthcare system, and she's been really plugged into their processes, and her expertise completely runs that program. I sadly have not been able to work on anybody with the Show Me Homes program, but it seems like a very beneficial program to take part in. Next slide. We work with practitioners across the country to submit Friends of the Court briefs to the U.S. Court of Appeals for Veterans Claims, U.S. Federal Circuits, and the U.S. Supreme Court in cases that impact veterans and service members. We just try to be able to inform federal judges of what these legal issues will do to different veterans and just make sure that they understand the law exactly and exactly what their holdings will cause for veterans. Our clinic has led the NLSVCC Amicus Advocacy Committee since it was founded in 2015. And so far, we've submitted 37 briefs to various federal court sets. Next slide. We hold an annual symposium every year. Save the date because the next one is upcoming on April 10th, 2026. You can see down there some of the previous topics that we've had. And this symposium is an opportunity to gain MCLE credits, and it offers great cross-discipline discussion about the unique challenges to the military and veteran community. This is also offered through a live stream. These programs are really nice to be able to just learn, get a deeper learning on a specific area of this practice of veterans law. Next slide. And of course, the best part of the clinic experience is working directly with the most deserving clients, working with veterans and being able to help them with their situations, and even just lending an ear, because a lot of them have been going through this alone and they really enjoy just being able to tell somebody and have somebody like face to face actually care about what's happening to them and not feel like they're just completely doing this alone. But calling a veteran and telling them that their case is finally done and that the VA finally got it right and they're getting their payments and their retroactive payments is just such a good feeling. At the Veterans Clinic, primarily we'll take on two kinds of cases. The first one is disability compensation, getting something service connected and then getting them to be able to get paid for that by the VA. And that's about 70% of our cases. And discharge upgrades, which is about 30% of our cases, which is just getting somebody's status at discharge upgraded to hopefully an honorable. The character of discharge claims sort of straddle the line because they're used in discharge upgrade cases, but in the VA system as a quicker way to open access to some benefits through the VA while the discharge upgrade is pending in the DOW system. So now I'll be turning it over to one of our staff attorneys, Katie Becker, to give an overview of VA disability compensation. Thank you.
Hi, thanks, Braden. I appreciate it. I'm going to be giving you all what can only be described as a 30,000-foot view of the VA disability compensation system. We're going to be hitting on a couple of areas that we see veterans most in need of assistance and how we can all kind of navigate those to the benefit of those veterans. Slide, please, Hannah. Thank you. So, of course, if you're here, you've likely heard of the Department of Veterans Affairs. It is a massive, massive department, second largest budget in the federal government. Of course, it's a part of the executive branch. The Department of VA is tasked with administering benefits and services to folks who have served in our military and helping to take care of them, after their service ends. Generally, it's important to note that the VA can be divided into three big subcategories. Most importantly, for the sake of this presentation, the Veterans Benefits Administration is the system that administers the benefits that I'll talk to you about today. It's also important, though, to note that the Veterans Health Administration plays a really significant role, number one in our society, but also in veterans cases. So they are the folks who administer the veterans hospitals and medical centers across the country, which so often develop the kind of evidence that we use in support of our clients' cases. Last but not least, the National Cemetery Administration is tasked with administering some of the burial benefits and administering the national veteran cemeteries across the country. Slide, please. Okay, so as we talk to our students a lot about, right, veterans law is fundamentally an administrative law practice with a twist. I also say an administrative law practice with a beating heart. When we perform work on behalf of our clients, we're interacting with a couple of different authorities. That starts, of course, with congressional statutes found in Title 38 of the United States Code. Those statutes are then implemented by regulation, which is in Title 38 of the Code of Federal Regulations. And it's worth noting that often the agency will develop practice materials that we have to be aware of. They're not always binding, depending on where we are in the system. But it's important to note that they can be persuasive authorities for us. On the right, you will see generally the hierarchy of things. So at the first stage, veterans are interacting with regional offices across the country, which then filter upward to the Board of Veterans Appeals, which is the highest administrative body in the VA. From there, we go outside of the system to the United States Court of Veterans Claims, which is an Article I court created relatively recently in the scheme of things in the late 1980s to review board decisions that have been issued. From there, veterans have the ability to appeal to the Federal Circuit and then also to the Supreme Court, which we are seeing in increasing numbers. Slide, please. For that reason, and because veterans have the right to appeal upward into these courts, then of course, we want to generally be aware of what's the case law coming out of the Court of Appeals for Veterans Claims, what's going on in the Federal Circuit, and then increasingly what's happening at the Supreme Court as well. Slide, please. Many of you, I'm guessing many of you here at this webinar do not practice veterans law, maybe not yet. There are some interesting flavors to veterans law that I just want to pose to you. Generally, the VA system is built to be pro-claimant. In some ways, we describe it as paternalistic. There are certain ways that the system is meant and purposed to help veterans. There's no formal opponent, there's no trial. Res judicata doesn't totally apply. Veterans can file multiple claims on the same topic over time, although there are a few exceptions. We have things like sticky favorable findings that my colleague Jessica will talk about within her section. And I think most importantly, the veteran system has the lowest standard of proof of any civil legal system in the country, and that is at least as likely as not. So if anyone has grappled with beyond a reasonable doubt or proponents of the evidence, just note that within representing a veteran's case, that standard is at least as likely as not. We are going towards equipoise. If it is there, then the benefit is supposed to be given to the veteran. So in many ways, the system is built to be very veteran friendly. Slide, please. Now, despite the fact that it's built to be extremely veteran friendly, there's plenty of opportunities to help folks navigate this particular system. The first fight that one can have on top of or in representing a veteran's case is actually the fight over, is this person a veteran? So veteran is a legal term of art that you see here. It is a person who served in the active military, naval, or air service who was discharged or released from under conditions other than dishonorable. So you see in Statute 1110, basic entitlement, we generally have 4 different sections, right? So does this person have a disability? Was that disability contracted during their service in some way, which could be active duty? It could also be active duty for training or inactive duty for training for reservists or National Guardsmen. The third component is, what is their discharge status? How are they exiting the military? What's their status at that point? And fourth, was that disability the result of something else? Was it the result of willful misconduct or abuse of drugs and alcohol? So already here, we all know the term veteran, right? The legal definition has multiple component parts. Slide, please. You'll see implementing regulations, which I'm not going to spend too much time with, but just for your reference, VA kind of subdivides veterans or former service members down into 2 categories, those with dishonorable service and those with service that is other than dishonorable. So they create kind of a binary, and we'll get into that in just a minute. Slide. Thank you. So folks who have interacted with the Department of War in some capacity will know generally, and even though, those who have not will know that folks are exiting out of service with a particular characterization of their service. The highest and best is an honorable discharge, but, there are other discharge statuses that exist. I want to reference them specifically for our purposes because this is explicitly referenced by the definition of veteran. And VA generally will consider folks with an honorable discharge a veteran for purposes of VA benefits. They will also consider someone with a general under honorable conditions discharge as a veteran. But anyone who receives a discharge status that's lower than that will fall into that dishonorable category. So slide, please. The reason this is relevant is because the type of discharge status someone exits with will shape the menu of VA benefits that they can access. So someone who is leaving service with an honorable discharge will be able to access, or is eligible to access anything that they might be entitled to. So that is first and foremost, disability compensation, but also VA healthcare, the GI Bill, VA mortgage assistance. They'll get, they're technically able to access all of it. For general discharges, they can access everything but the GI Bill. And we know, of course, that that's a major motivator for a lot of folks going into service. So that can be a pretty tough obstacle to navigate. Lower than that, generally people with other than honorable discharges will receive access to VA healthcare, but very pointed access. And it's specifically for conditions that they can show are related to their service. But again, they're not getting money for it. They're just getting healthcare. And folks with a bad conduct discharge, dishonorable discharge, they're not going to be able to access, they won't be eligible to access anything in terms of benefits. So slide, please. Often, just a little logic game for you. All veterans are former service members, but not all service members are veterans. Folks who fall into those lower categories may want to access benefits that are only available to people with higher discharge statuses. So within the VA, there's a mechanism called a character of discharge determination that allows someone to ask the VA to treat their discharge status as higher than it is for the purposes of accessing VA benefits. This is often based on mitigating compelling circumstances that occurred during their service. There's an explicit insanity exception. There's policy changes. or there's improper discharge procedures that were followed. If they can show that, then VA will recognize them as or treat them as having a higher discharge status than they do. There have been a lot of kind of favorable changes to the scheme lately, so I just want to flag that for you. Just to be aware, there are statutory and regulatory bars that might be applicable in a veteran's case. So happily, if the COD goes through, then the VA will treat the veteran service as not dishonorable. Slide, please. Now, one of the reasons someone might want a COD is based on the subject of what we're talking about today. Maybe they want access to VA disability compensation. Generally, there are 2 monthly benefit programs administered by the Veterans Benefits Administration. This is a tax-free benefit. The first is what I'll talk about today, VA disability compensation. And the second is VA pension, which my colleague Eugene will talk a little bit about later. Notably, disability compensation is available for folks who generally can prove that they experience a condition of some kind that is causing them impairment that's related to their service in some way or their resulting disabilities. Slide, please. Just to give you the menu of things that we will really only briefly touch on over the course of this conversation, but there are 5 different theories by which someone can get access to monthly benefits related to their service or resulting conditions. We're going to talk about each of these. They all have their kind of different flavor. I would say the basic nuts and bolts of this system is the first, direct service connection. So slide, please. We'll start there and we'll dig in. So generally there are three elements to direct service connection. And this is a theory that will be used by someone who is looking to establish that a current disability or symptoms that they have are related to their military service. So the veteran will need to show that they have a current disability or symptoms. They will need to show 2, that there was some kind of in-service event, injury, disease, exposure, cumulative injury that they experienced in service, and 3, a relationship between those 2 things. So we have so many examples, and I'm going to dig into this one in just a little more detail in just a slide, but there are so many different examples of disabilities that folks have or symptoms that they're experiencing that could somehow be related to service. By way of a few, a knee condition, a knee injury during service that never got better after and continues to impact them to this day. Maybe it's a traumatic experience during service that has resulted in a current diagnosis of post-traumatic stress disorder. Traumatic brain injury related to an IED accident during service. Cancer, that's related to some incident or exposure during service. The list goes on. And we see it's very common that folks have not just one disability, but many. So it's a wide net that we're casting here. Slide, please. Generally, a few ground rules, because this is the condition by which most folks get compensation. The first element is a current disability, which should not surprise you. That does require a present disability. So it cannot be, I had it, but it's gone now. And it also can't be, I might get it in the future, right? It's not a speculative kind of filing. It has to be pretty concrete. Generally, medical evidence is required to prove that the disability exists. It's worth noting sometimes lay testimony is enough. We have a few combat medics that we represent whose testimony are able to establish that that they have current, particular types of current disabilities. For others, there are particular types of conditions or particular types of testimony that might be enough to establish that the veteran has a current disability, but the vast majority, you're going to need some kind of medical evidence. So VA healthcare records coming from the VHA can be really helpful in that respect. Slide, please. The second element is an in-service incurrence. So that could be an in-service event. an injury, a disease, an exposure, a cumulative injury, basically something that happened during service that the veteran can point to establish, what's going on with them now. I want to just note, folks tend to think like, okay, in-service event has to be deployment related, has to be combat related, has to be related to your duties, and that's actually not the case at all. So for the purposes of veterans law, in service is just between the first day that you enlisted and the last day that you separated. So we have a lot of folks who have sports injuries during, or during PT, that have just lingered on since then. Now, as to the last element, we're going to need a medical nexus, which in the vast majority of cases is some kind of, letter from a private treating physician or a VA doctor that establishes that the current disability is related to the in-service event. Slide, please. A second and slightly rarer theory to receive disability compensation is aggravation of a pre-existing condition. It's worth noting it's not as common as direct service connection, but so many of our folks who enter into the service are active before they do so. Their, high school injuries happen, right? They played football or something. So if someone, generally there are three elements to seeking compensation for the worsening of something that you had before service. You need to show that you had a pre-existing condition, that it worsened during service, and that the worsening was beyond the condition's natural progression. So generally, you had a knee injury from football. It was noted when you were getting into the military, but lo and behold, it got worse over the course of service, and that's beyond what would be expected out of its natural progression. A slide, please. Secondary service connection is something generally Congress means to compensate folks for the results of their service, which can include the things that happen as a result of their service-connected disabilities. So there are three elements here. Generally, you're going to need a foundational service-connected disability that's happened. You're also going to need something to link to it. So an example is a knee disability that's service connected, for which someone has been prescribed a whole lot of Motrin, which has then caused ulcers, right? So generally you've got a service connected knee disability, you've got an ulcerative condition, and you would need to show evidence of a relationship between the two. So this can be a causal effect. It can also be an aggravating effect. I note C and D here. They arise from some of the case law, but they're going to be slightly less common. And just to note for any of our torts folks or personal injury folks on the call, secondary service connection can contemplate like multiple steps in the causal chain. So you don't have to necessarily stop at just one if your veteran is, has a number of different injuries. Slide, please. Next, if you are interested at all in toxic exposure / maybe a few elements of government conspiracy theory, presumptive service connection is also available to veterans. So this is, I think, the most obvious and best example is Agent Orange exposure in Vietnam. There are certain types of conditions and types of service that the VA recognizes resulted in certain conditions or experiences. So a veteran who serves in Vietnam or Camp Lejeune or some of the other enumerated conditions would need to show that they had some kind of qualifying identifiable service for which or after which they developed a qualifying condition, and that condition is not attributable to another cause. So in these issues, the government recognizes that common groups of folks experience common groups of conditions afterwards. Agent Orange is the best example. Folks who served in Vietnam during certain periods of time were exposed to Agent Orange. They later developed a certain, array of conditions, including diabetes type 2, And VA recognizes that and has created presumptions that get rid of that nexus element. So the law steps in and recognizes, oh yeah, these things are related. Slide, please. Last but not least of the theories of disability compensation are 1151. This is VA medical malpractice. So if something happens in a VA facility or because of VA medical treatment, a veteran can get service connected for that. This is the closest we get to medical malpractice and personal injury within the veterans law framework. So I just wanted to flag those like that for you as well. Slide. Okay, so we've got these wonderful, well-developed theories by which you've requested all of this evidence to help a veteran. What will generally happen is the veteran or you will submit a claim. So that claim gets received by the VA. VA will go through the evidence that you submit, which often will include records or affidavits from the veteran or their loved ones, battle buddies, etc. VA will review that evidence. If they find that a few different grounds are met, then they will send the veteran to what's called a compensation and pension exam, which is a free examination conducted by VA contractors that is supposed to provide the VA with information about these different elements. So the connection between, the veteran's current disability and the things they experienced during service and provide them with information. At that point, VA will then issue a ratings decision. Slide, please, Hannah. So if you have never seen one, they generally look like this. Relatively boilerplate. Just to say, here we've got some discussion of the symptom set with post-traumatic stress disorder and TBI. I'd encourage you, if you're working with veterans, to read it very diligently. There's going to be a lot that's going to be left out. So having a good grasp on what did we submit, what did we provide with the VA, and what was the result is pretty critical. Slide, please. Generally, after a ratings decision is issued, my colleague Jessica will talk a little bit more about what that process looks like. But just to say, if the decision gives the veterans something less than everything they asked for, then the veteran has grounds to appeal. Common reasons to appeal a ratings decision is if service connection for a condition is denied, or if service connection is granted, the VA, when characterizing the severity of the veteran's condition, lowballed them, right? It's more severe than they made it think, or they were assigned an effective date for payment that is later than when they began this fight for benefits generally. And we'll talk about both of those next. Slide, please. Thank you. Disability ratings. So generally after service connection comes the fight for a veteran's disability rating. VA will issue a percentage in the veteran's case, somewhere between 0% and 100%, that is supposed to contemplate their functional impairment and earning capacity. Those will be in increments of 10% normally. Each particular condition or type of condition has its own menu or rating schedule where these conditions are listed and then the symptoms that VA looks at are identified. Things that are just interesting to see is the vast difference in what's contemplated by these rating schedules. So some are recognized as contemplating a huge variety of symptoms. Some are very limited. Some require subjective evidence. Some require objective evidence. And I'll show you in just a minute two different ones that I think have a nice contrast. So let's turn, slide please, to the hearing loss rating schedule. This is one of the most diabolical. Generally, it's based on objective hearing loss test scores, which can make it pretty difficult to fight against. Generally, the veterans' test scores are compared with their speech discrimination scores, and the score you get is what you get. That's in contrast to the next slide, which is our mental health condition list. So here we have general, we have identification of particular symptoms contemplated by each level. and generally the impact on the veteran's life. Are they totally occupationally and socially impaired, contemplated by 100%, or maybe they have a diagnosed condition, but it doesn't interfere with anything. That's a 0%. This is far more symptom subjective than objective test scores. Slide, please. Okay, so once your veteran gets a rating for their condition and likely gets multiple ratings for their conditions, those ratings are combined via VA math, and this will shape the amount of monthly compensation they get. I've included a couple of different degrees for reference. 10%, you're looking at 176. 100%, you're looking for 3,974, right? And there are increments in between each of those. Noteworthy, veterans can receive additional compensation for family members once they clear the 30% threshold. I just want to note that VA math is not like normal math. So it's a math of diminishing marginal returns. The higher a veteran's score gets, the harder it gets to advance that. So generally there's a formula, although I would really refer you out to some really good disability calculators that are available online. For context, a veteran with a combined 90% disability rating will need an additional 50% to get up to 100. So it gets harder as it goes. Slide, please. Generally, if you're contacted by a veteran to help increase their rating, you have 3 general strategies to be able to do that. You can either increase their individual ratings that they've already established. You can help them get higher or get more conditions service connected, which indirectly will increase their combined rating. Or you can assert that they should be treated at the 100% level because they are unemployable as a result of their particular service-connected disabilities. So I just want to flag that for you all as well. Slide, please. Now, the last area of fight on behalf of veterans are effective dates. So when the VA grants service connection and assigns the veteran a rating, they're also going to assign them an effective date. And this is the date that the payment for that condition will date back to. So generally, it's going to be the later of 2 things: the date entitlement to benefits arose, or the date that the veteran filed the claim at issue. I want you to note there are many different exceptions to this particular rule, so I've identified some of those statutory and regulatory bases for you. Slide, please. A couple of examples. Maybe the veteran filed what's called an intent to file. You'll hear a little bit more about that after. Maybe they qualify under the specific discharge upgrade provision that allows for an earlier effective date. Maybe you're able to show that the VA mishandled an earlier claim. Maybe you're able to show that the veteran has been pursuing this for 30 years and should be paid for each of those 30 years that they've continuously pursued it. A couple other grounds that are making their way through the federal courts. VA provided the veteran with an adequate notice, or there's generally an exception to the general rule. We see, constitutional grounds being made on why an earlier effective date is warranted lately, which has been pretty cool to watch. Slide, please. So if you are interested generally in helping someone, fellow service member, number 1, be recognized as a veteran, or filing for service connection, asking for an increased rating, getting an earlier effective date, what you can do is you can get accredited. So agents or attorneys must be accredited. It's a relatively easy process. It's an application to the VA Office of General Counsel. You need to self-certify or provide admission information about your admissions to different areas. There's a determination of character and fitness, although there's a presumption that if your state recognizes you as a person of good character and fitness, then VA will as well, although that is rebuttable. And then, of course, you have to complete 3 hours of CLE credit during your first 12 months of initial accreditation. So we're glad to see you here because that's the whole point. Slide, please. So once you are actually accredited, just to note that there are continuing kind of accreditation obligations. So there's an obligation to complete CLE 3 hours of CLE over a period of time, and then an annual self-certification of completion and good standing. So, hopefully we'll see you all here maybe next year. So that is a very quick, very big picture overview of VA disability compensation. I welcome any particular questions that you might have.
Katie, we have one question lingering in the Q&A, kind of referencing back to the presumptions, what we've kind of lovingly called government conspiracy theories. Can you just kind of expand on what some of those examples are?
Yeah, so that's the kind of the closest veterans law comes to mass torts. When I say conspiracy theories, it's generally conditions where we as a society now recognize that things were happening that were impacting large amounts of people. So in Vietnam, it was the use of Agent Orange, and over time, learning about the negative effects on health that those dioxins had. It's Camp Lejeune. There was contaminated water that at the time wasn't known about, but over time has been, we've learned more about, and we know more medically about some of the adverse impacts about that. Some of the most recent presumptive conditions and qualifying service have been related to burn pits, right? The use of burn pits in Southwest Asia, but also other places, and some of the respiratory conditions that can result from long-term exposure to burn pits. So those are just a couple of examples. Presumptive service connection is very much an issue spotting exercise, and I would really encourage you to take time to look at the statutes, look at the regulations after you've had a conversation with a veteran to say, okay, did this person serve at this particular place during this particular time?
Thanks, Katie. One more question, kind of generally about VA accreditation applications. Do we know what the timeline for those tend to be?
I don't. Yeah, unfortunately, I don't know. I mean, I can only speak of my experience, which was relatively quick. I'd encourage you, there's this community is a really open one and a really great kind of sharing amongst others. So feel free to reach out, to us or to other folks that you know who are going into the process to get an idea, but I honestly don't know. I'm sorry to say.
Another question, just to kind of clarify, a dishonorable discharge and a bad conduct discharge, what are the bars there? What benefits are they, if any, qualified for?
So generally, folks with a dismissal, a dishonorable discharge, or a bad conduct discharge are not technically eligible to file or eligible to access VA benefits. I want to just note that those folks can go through the character of discharge process, right? That's open to them. And so that would be an avenue where you would want to you would want to see if you can help. As to the statutory and regulatory bars, those are enumerated by statute and by regulation. Those are particular conditions or particular types of conditions that will likewise make folks not eligible to receive VA benefits. So I think I answered most of that question. And I would just point you towards some of the statutes and the regulations on that. Note, if anyone has interacted with the DOW process, what we're talking about here, the character of discharge determination, is a purely internal VA process, right? That's not kind of changing the actual official paperwork that the veteran gets getting out of service. Yep. Okay. And just to say, we have someone who's talking about accessing VA healthcare under Chapter 17. That is, that's what folks with under other than honorable conditions discharge can get. They can access VA healthcare. They just can't get disability compensation. So it's a limited form of VA healthcare treatment. Okay. All right, everyone. Well, thank you very much.
Hello. So Katie did a great job talking about what the avenues are for filing for claims, and I'm going to talk about how the claims are filed and the appeals options for the veterans. So I'm going to talk about the Appeals Modernization Act, also known as the AMA, which represents the largest overhaul of the VA appeal system since 1933. So it's a shift from a more linear system, which is called the legacy system, to a multi-lane system with multiple entry and exit points. So the AMA was designed to give veterans more control and to clarify expectations on their appeals options. Slide. So the effective date of the AMA was February 19, 2019. And that marks the dividing line between the legacy and the AMA system. So what that means is that the AMA applies automatically to all decisions that occurred on or after that date, regardless of when the claim was actually filed. There was an option right after the enactment of the AMA, which was called the ramp system, for veterans to opt in to the AMA while they were in the appeals process for the legacy system. However, once they're in the AMA, there's no option to return to the legacy system. Slide, please. So why the AMA? The legacy system had been known to have wait times of upwards of 5 to 7 years or more, and veterans were required to complete each stage before moving on to the next. There were bottlenecks, the appeals were duplicated, evidence was overlooked, and so the AMA was created to create parallel lanes of review, to require the duty to assist at certain times in the process, and to provide clear, actionable decision notices. So Congress designed the AMA to increase speed, transparency, and increase the choices that the veteran can make through the appeal process. Slide. So this is just to show you how the legacy system used to look. It's obviously pretty convoluted looking, very confusing for veterans, anyone involved in the process. Slide. And this is how the appeals process looks now. Still a little complex and hard to follow, especially for veterans, but it's a little bit more manageable, keeping in mind that the filing deadlines are 1 year. Slide. So the definition of a claim is a written or electronic and submitted on a prescribed form. So previously, informal claims and handwritten statements were allowed for veterans to file for initial disability claims, but there are specific forms that are required now to initiate that process. So there are two types of claims, initial and supplemental. I will go over the difference between the two. Slide. So initial claim is any complete claim other than a supplemental claim for the benefit. And that can include a claim for disability, granting new benefit, an increase in rating for a worsening condition, or any of the options that Katie talked about in her brief. And so the difference between an initial and a supplemental is that a supplemental claim are for basically a reopening of previously decided issues. And so the supplemental claim is a route that is available to add more evidence to a claim that has already been decided. And so the supplemental claim is available because it can be filed repeatedly, and some options that we have used are for to include a new medical nexus opinion in support of a claim, newly discovered records that were previously not known or provided to us from the National Personal Records Center, and private treatment records that the veteran has provided from their doctor. A slide, please. the VA does have a duty to assist, and Katie talked about this a little bit, keeping in mind that the duty to assist is required only in the initial claim part of the process. So not in the HLR or the board lanes in the appeals process. So what that means is if there is evidence that was missing or the VA did not provide, a supplemental claim might be the best option. The AMA also improved the decision notices that were required to provide to the veteran once they made decisions, to show that they actually took into account all of the evidence and provide their reasoning for any such denials. So what this does for us and for you, hopefully as you work in veterans law, it'll help you to avoid guessing what the basis was for denial and provide ways of which to provide a strategy in carrying out the appeals process. Slide, please. So the AMA added the decision notices must contain these specific items. And so when you're going through and looking at decision letters, as Katie showed you earlier, you would have seen that there's a lot of paragraphs in there. And so taking each line by line, making sure that all of these required items are included helps you along with the appeals process. Slide. Additionally, the huge benefit to the AMA is that favorable findings cannot be reversed unless there is a clear and unmistakable error in the favorable findings. So any subsequent decisions that were made as in regards to that particular claim are going to be upheld. So for example, if you see in the decision a statement that says VA concedes that an in-service injury occurred, or that the VA confirms a current diagnosis of PTSD, or the VA finds a chronic condition existed, any of the subsequent decisions as it pertains to that claim have to take that favorable finding into account. So once a decision is made, there are three options for an appeal. So it is, as I stated earlier, built around a 1 year decision window. And so the veteran and yourself representing them will need to decide what options that you want to take as far as the next steps. So you can file a higher level review, a supplemental claim, or an appeal to the BVA with a notice of disagreement. And I will go over each of them individually. Slide, please. So this is just to show you that this is a piece of paper that is usually in page 9 or 10 of a decision that the veteran receives. So it's often overlooked. It's kind of hard to see right now, but this is the only paper that the veteran will get, which talks to them about the appeals options. And so as you are looking at the 15 to 20 page decision document, this is where you can find some of the things that I'm talking about today. Slide, please. So the higher level review is a de novo review based evidence. So something that has to, that a more experienced adjudicator will look at after a decision is made. So when this is conducted, no new evidence is allowed, the record is closed, and you can request for an informal conference to talk about any clarifying arguments, to point out evidence that is clearly overlooked, and to just have that discussion with a VA representative. So after an HLR, a corrected grant or a denial, as well as a duty to assist error, can be found during at the end of that HLR. Slide. So to file an HLR as an initial claim requires there's a specific form. Can you slide, please? I think I'm missing a slide. So the HLR form requirement is a 20-0996, and it must be filed within 1 year of the decision. And so some good options to use this route is for procedural errors, a misapplication of the law, or misinterpretation of evidence that is in the record. So this supplemental claims is a second option to appeal a decision. And so this can be used if there is new and relevant evidence that you can attach to the claim. A lot of times we use this for adding a nexus opinion, newly received records, or presenting a new diagnosis. Slide. So the definitions required to meet that standard. New is that it's not previously part of the record before the agency, and then relevant tend to prove or disprove a matter at issue in a claim. So things also outside of the norm that you can provide are even news articles, any changes to the DSM, lay statements, and anything in support of your veterans claim. So the evidence does not need to guarantee a grant, it just needs to be able to support that claim. So please. And then the last option is to file a notice of disagreement using the form VA Form 10182. And the last slide of this slide deck will reiterate all the forms that I talked about here. So the notice of disagreement must identify the rating decision that you disagree with, the issues that you are appealing, and the board docket lane that you choose. And there are 3 lanes, and I will go over that in the next slide. So the direct review is the fastest lane. There's no new evidence, and we would recommend using this when the record is strong, especially because this is it'll take an average of 365 days a year. So the second lane is to request a hearing. This is where a veterans law judge will conduct a hearing, and it's best for when there's credibility issues or complex medical histories, and they will take into account evidence that was submitted at the hearing and 90 days afterwards. And then finally, evidence only, the BVA will consider everything that they already have as part of the record. And there's no hearing, and of note that this is a slower than the direct lane, but faster than hearing. Slide, please. So of note, when you're considering which appeals avenue to take, you can decide strategically to go multiple routes, depending on how you can separate your veterans claims. So for example, if you have a knee condition, you can file an HLR for an error. In an ankle condition, if the veteran also has an ankle condition, you might consider filing specifically a supplemental claim with new evidence, even though they are seemingly tied together. The flexibility with the appeals claims is that you can switch between HLR supplemental and a BVA notice, but it must be within the 1 year of the initial decision date. And it must be for a good cause. If you switch after the year, it must be for a good cause and must be approved. So these are the forms required to file the corresponding appeals with the VA. Any questions?
Thanks, Jess. I don't see anything in the chat, so I'll give it just a few seconds and then we'll go ahead and move on if there are no questions.
Thank you.
I think we're good. We're going to go ahead and move to pensions with Eugene.
All right, everyone, thank you. My name is Eugene O'Loughlin. I'm the advocacy coordinator here at the Veterans Clinic. I've been here about 4.5 years. Prior to that, I was with the Missouri Veterans Commission, where I estimate I filed about 5,000 claims for pension or survivor's pension. So I'm quite familiar with this program. So next slide. The pension program is it's actually a very simple program to understand when you break it down into the 3 criteria needed for this benefit. There are 2 different pension programs. There's the live pension as well as the survivor's pension, and these are all based on they're eligible for wartime veterans that meet net worth criteria and income criteria. So those are the 3 components, much like the 3 components for the non-service connected disability pension. There are 3 components to the pension programs: wartime service, net worth below a certain threshold, and income falling or below a certain threshold. So next slide. So the non-service connected disability pension, it is a needs-based program for veterans with wartime service that are permanently and totally disabled or over the age of 65. The VA does consider those that are over the age of 65 or those that have reached the age, the accepted age of retirement, to be disabled to the point where they should be able to qualify for this benefit. If they're under 65, then they have to have that permanent and total disability that prevents them from working. And keep in mind, these are disabilities that are not related to their service. So, and the VA, a veteran can receive either the non-service connected disability pension or the service connected disability compensation, but they can't receive both. So, if they're eligible for 100% service connection, which pays them almost $4,000 a month, then it doesn't really serve a purpose for them to apply for the non-service connected disability pension because that maxes out at about $2,600 a month. So that's, a little bit of background with this. It all kind of started out with the survivor's pension benefit, actually. That goes back to the days of the Civil War, where President Lincoln basically said, our duty as a nation is to care for the fallen, the widows, and the children of those that died in the Civil War. That's kind of how all this got started. So next slide. So it is for veterans, surviving spouses, and dependent children based on their eligibility. There's a base pension. There is a housebound rating in the event that they require assistance with some of their activities of daily living, or the aid and attendance level. And, one of the things that you're going to run across if you're working with nursing homes or assisted living facilities, everyone always talks about the aid and attendance program, the aid and attendance program. It's something that you hear a lot. And once you understand that the aid and attendance program is the highest level of benefit applicable to the pension or the survivor's pension, it makes it a little bit easier to understand what this is. Next slide. So in order to be eligible for these programs, just like Katie was explaining with the compensation benefits, you have to be honorable or generally discharged. In order, you got to be above that threshold. You got to be under honorable conditions that your discharge is. There is minimum time criteria prior to that date, September 8th of 1980 or September 7th, sorry, or October 16th of 1981 for officers. Prior to that date, you had to have 90 days on active duty other than for training to meet the minimum criteria, basically to be deemed a veteran. And then after those time periods, September of 1980 for enlisted, October of 81 for officers, you need 24 consecutive months, or you have to have been on active duty for the entire time that your unit was activated and deployed. So I had a he was an Air National Guard member whose unit was activated and deployed for the Gulf War back in 1991 for a total of 87 days. But because he was activated and deployed for that entire 87 days, he met the criteria for this program. So that is, because most of the time your National Guardsmen reservists, they're not activated for 24 consecutive months. They're activated for one tour of duty. Typically that's a year, but it can be a different amount depending upon the needs of the military. So they need to have part of this criteria that the first criteria is they have to be a wartime veteran, okay? Honorably, generally discharged, meeting the minimum criteria, but how much wartime service do they need? 1 day. They only had to have served with it for 1 day during that wartime period, and they did not have to serve in combat. They could have never left the United States, but they've served during that time period, so then they are eligible for this program. Next slide. Again, it's a disability-based program. So again, there needs to be over the age of 65, permanent and total disability prior to that age. If they're a person in a nursing home, long-term care facility, or if they're in receipt of Social Security disability or supplemental security income. In those situations, another federal agency has basically deemed them as totally and permanently disabled. So, because again, it is the non-service connected disability pension. It's just these are not service-connected disabilities. Next slide. Wartime service, I've listed the dates for you based on the based on the VA's determination of the wartime periods, starting August 2nd, 1990 through today. It's still deemed a wartime period because we are in skirmishes all across the world still. So they just need to have served for 1 day during any of these time periods. Next slide. So net worth guidelines. So the VA, this is a program that was designed to make sure that people's minimum needs are being met. Okay, this is not a program that was meant to allow you to pass more money down to your heirs. Okay, it is a program that is very beneficial at slowing down the need for Medicaid. So whenever you're thinking Medicaid, This is the step above that. Okay, there is a net worth guideline. There's a maximum amount of money. Um, Currently, it's $159,000 and change. And every year now that will go up based on the COLA increases. That $159,000 that they have excludes certain things like the value of their primary residence. It excludes things like their one automobile. It excludes things like their furniture, clothing. I like to explain it that um, it excludes everything that they use every day. Their assets are the money that they have, put aside for the future, for the medical needs, if necessary, for a nursing home, assisted living facility, that kind of a thing. There's a 3-year look back, just like the Medicaid's 5-year look back. It's very simple. You can't give away your money in order to get a federal benefit, and if you do, then the VA is going to basically penalize you for potentially up to those 3 years and say that you're not eligible to receive that benefit for that time period. Go ahead, next slide. So there's our $159,000 for this year. Um, and the home can be on up to 2 acres. Anything above that, if it cannot be subdivided, if you're sitting on a on a plot of land that is 3 acres and your homeowners association requires a 3 acre minimum type of a thing, and they can't subdivide that land, then the VA is going to, basically just say, okay, that's not going to be listed as separate. But if they have uh, vacation home down at the lake or wherever, that is going to be counted as their net worth. So the net worth is going to include things like checking, savings, CDs, stocks, bonds, mutual funds, annuities, trust accounts, vacation properties, stuff like that. It's also going to include the previous calendar year's income information minus the previous calendar year's medical expenses. So they do use this program uses medical expenses to offset the income. Okay, 3 different um, components to this: the wartime service, the net worth, and the income. Okay, so the net worth is the second step to this. Next slide. So again, a little bit more information on the net worth guidelines. It used to be an $80,000 threshold that was all dependent upon how long you were predicted to live and life expectancy and how fast you were using your expenses, your net worth. They've kind of simplified that because this program for many, many years was just grossly taken advantage of. And the VA kind of tightened the belt and said, we need more definitive information. So that's why a lot of these changes came through in 2018, most of which most people kind of have a good understanding about it. Next slide. Calculating the penalty period. Okay, again, there's a 3-year look back on this. If you have $500,000 and you turn around and give $400,000 to your children and keep $100,000 so that you can qualify for this program, well, great, that's wonderful. Just keep in mind you're not going to be eligible for this program for the next 3 years. In a nutshell, that's what it's basically saying. Next slide. Okay, the income, the third leg of this program. There is a minimum amount of money that the VA says that a wartime veteran should live on. Okay, for calendar year 2025, they say that an honorable or a generally discharged veteran that has less than $159,000 in net worth and assets should live on no less than $16,965 a year, which equates to approximately $1,413 a month. So for that veteran that has no income, their disabilities that are making them permanently and totally disabled, that has not reached the age of 62 yet and can't even take the reduced amount of the Social Security disability. The VA is going to basically say that that they're going to issue them about $1,400 a month to ensure that they are, you know, they have enough money to kind of care for themselves, support themselves. In the event that they are in need of housebound benefits, that goes up a little bit, almost $290. And then there's the aid and attendance level of care, which basically says that they should live on no less than $23.58 a month. Well, makes a little sense. It costs more to live when you have more health issues. Next slide. The mapper. Okay, so the VA, the federal government, believes that everybody should pay a portion of their own medical expenses. So the VA does use medical expenses to reduce the amount of their income. And in that event, if it drops further below or drops below that threshold, they still could be eligible for this program because of those medical expenses reducing it. So for a single veteran, the VA says that they should be required to pay $848 a year, okay, of their medical expenses. Surviving spouse, it's $569, and if they're married, it's $1,100. These numbers, that number can actually vary if you have a veteran married to another veteran, just like they do for a married veteran under the pension program. There's higher amounts when it's a veteran married to another veteran. Go ahead and next slide. So those married veteran, not these, for a married veteran married to a civilian, not another veteran, those dollar amounts do increase as demonstrated here. You know, it was $1,620 some odd dollars for a single veteran, but a married veteran, it goes up to $1,853 because it does cost more for two people to live. But it doesn't quite cost double because they don't have two mortgages, they don't have two rents. They have less expenses than two individuals do. And again, if the veteran requires the housebound, meets the housebound rating or the aid and attendance rating, those amounts go up. Next slide. So we've been talking a little bit about housebound and aid and attendance. So what is housebound and aid and attendance levels of care? So the veteran is deemed housebound if they are in fact confined to their residence or they need assistance in leaving their residence. If they are have a great deal of difficulty ambulating or transitioning from a chair to standing. Um, uh, they are unable to stand for long periods of time. They don't have to be in their house. It's not like a housebound, like you're bound to your house, but you're having a lot of difficulty with ambulating, moving around, even dressing and undressing sometimes. You don't have to reside in a nursing home or an assisted living facility, but very often people that do reside there qualify for most often the aid and attendance level of care, but sometimes the housebound level of care. Go ahead, next slide. So the aid and attendance level of care is when the veteran would require assistance with all of their activities of daily living. They need assistance with their medication management, with the preparation of their meals, with their medication management, with their personal hygiene needs, with their ambulating, dressing, undressing, transportation. They really do either need to be in a true nursing home, in many assisted living facilities, or they could be living in their own home, but yet someone is coming in pretty much every day to make sure that they're eating properly, that they're taking their medication, that they're showering, that they're wearing clean clothes, that they're, uh, getting along okay. So again, that housebound and the aid and attendance level of care could raise the thresholds for a veteran in need of those types of care. Next slide. So in order to get the housebound or the aid and attendance level of care, a doctor must complete this form, a 21-2680, that would basically verify the fact that they need, these specific types of assistance. And in the event that they're receiving that assistance at home, they have to kind of explain, that someone is actually providing that level of care, those individual levels of assistance to them. So that form must accompany the application for the non-service connected disability pension. Next slide. Again, medical expenses can be used to offset that. So, if they are paying a premium for Medicare, if they're paying a premium for their supplement, if when they're initially doing the application for the pension, they can list the regular and recurring and predictable medical expenses. So the premiums for Medicare, the premiums for a supplement, a dental plan, vision plan, long-term care policy. The only insurance that they can't count would be life insurance policy because they are not the beneficiary of their own life insurance policy. Any in-home care, the cost of any in-home care. They're paying their neighbor, $100 a month to come in every other day and check on them or drive them to and from all their doctor's appointments. They're paying their daughter $500 a week to come in and bathe them and cook for them, prepare them meals, make sure that they're taking their medication. These are medical expenses that are regular, recurring, and predictable that can be used to offset their income on the initial application. But throughout the year, they should also keep track of all of their unpredictable medical expenses, all of their out-of-pocket medical expenses, the premium that co-payments for the medications, any medical expense really. The if you don't have dental insurance or the cost of the dental care that's not covered by the dental insurance plan, that is a medical expense that again could be used to offset your income and potentially provide a higher award amount. Next slide. Again, medical expenses, again, some examples of that, highlighted by the last two being assisted living facility cost or nursing home cost. Now, in order for these costs to be counted as medical expenses, the VA must deem the person in need of housebound or aid and attendance level of care. sorry, the bottom three, because the cost of care for assistance with activities of daily living. So the daughter that's coming in, caring for mom or dad, that needs to be, mom or dad needs to be deemed either housebound or aid and attendance level of care, along with the assisted living facility or the nursing home. So in order to count those things as a medical expense, they must be deemed in need of housebound or aid and attendance level of care. Next slide. Again, just another list. We can move on to the next slide. These slides are all going to be available to you guys. So the medical expense report. So at the end of each year, prior to the 2018 change, we had to submit what was known as an eligibility verification report. It was the verification of the income amount that the recipient, the pension recipient, was receiving from all sources. Due to the computerization of Social Security and IRS and VA, they no longer need the eligibility verification report to be completed because they can verify the income through IRS and Social Security. But all throughout, from the very beginning of this program, they can complete a medical expense report so that they list those out-of-pocket medical expenses along with the predictable medical expenses that they use to offset the income at the beginning of the year. So they're going to offset the income using the copayments for the medications, the dental care costs, the cost of paying their daughter every month to come in and take care of them, on a daily basis. The medical expense report is used to offset that. And I would assume, next slide, I have that VA form number. The 21-8416 is used to list the medical expenses that you would like to have the VA used to offset the income. Because I mean, using your hands, there's a minimum amount of money that the VA says that you should live on a month. If your income is above that threshold, we're going to use medical expenses to offset that. Obviously, the further down that we can reduce that using these medical expenses, the greater the amount of benefit that's going to be awarded. Of course, once you reach zero, you're maxing out the benefit. So for that single veteran where the VA says the minimum that they should live on a month is $1,600 a month, okay, once they have, if they're in an assisted living facility, that income goes up to $1,900 a month. That's the minimum threshold that they should live on a month, $1,900. If they're paying an assisted living facility $5,000 to reside there, obviously that $5,000 offsets all of their income. The VA is going to start them at zero, and they're going to award them the maximum amount available, which is that $1,900 to get them back up to that threshold. So medical expenses, very important. The date range on it is all based on from the effective date of the award. It all starts there. It gets a little confusing, but if you submitted the original application on July 17th, okay, the initial year has to be broken down from July 17th to December 31st, and then from January 1st of the next year through July 31st of the following year. And then you must do August 1st of the following year to December 31st of that following year. It's a little confusing, but once you picture it, it's not so bad. Go ahead, next slide. So applying for the non-service connected disability pension, there is the form. It is a 21P. My apologies. It's a 21P as in Paul, 527 AZ. you need to fill it out. It's a government form. You got to put in their social security number, the military history, the financial information to show net worth and assets, work history, bank account information, medical information. Again, you got to be able to prove he's a wartime veteran or she is a wartime veteran that meets the net worth guidelines, that meets the income guidelines. Next slide. Again, if you are going to be applying for the additional housebound or the aid and attendance level of care, you have to have a doctor complete the 21-2680 form. Next slide. The survivor's pension, it mirrors the pension program. Okay, it is for dependents, surviving spouses, surviving children, that surviving dependent children. So it could be a child that's under the age of 18, or it could be over the age of 18. However, they've been deemed incapable of self-support. They would still, prior to the age of 18, they would still be eligible for this. It's exactly the same program. Got to have meet the wartime criteria, honorable general discharge, meeting the time in service 1 day during wartime period. This is for the surviving spouse and the surviving dependent children. They need to meet the net worth or asset criteria. That threshold is $159,000. They've got to have less than that. And then the surviving spouse, the VA says that they should live on no less than $948 a month. It's not the Department of Veterans Spouses Affairs or Dependents Affairs, it's the Department of Veterans Affairs, which is why the veterans rate is higher than the surviving spouses rate. But at least it's something for the surviving spouses that are not eligible for the dependent and indemnity compensation program that Brent is going to be speaking about next. Same criteria that in the event that they require the housebound, that the surviving spouse requires the housebound or the aid and attendance level of care, that 21-2680 form must be completed by a doctor and submitted with the application. Next slide. That is the form number for the survivor's pension. I've got the P on that one, so it's a 21P 534 EZ. And obviously you have to include the veteran's service information, the DD-214, all the information on the veteran to include their death certificate. Next slide. So I've got some simple examples here. Homeless veteran, no income, no net worth, living on the streets. Deemed incapable of working because of not service-connected disabilities or disabilities that just haven't yet been deemed service-connected. They're still going through the appeals process. If they're a wartime veteran with an honorable or a general discharge that meets the net worth criteria, they very well may be eligible for the pension program prior to them getting the disability switched over to a service-connected disability. It puts more money in their pocket, kind of right away. And if they're deemed 30% for that PTSD that's related to service that pays $500 and change, here the pension pays them $1,400 a month. They would stay on that. You might want to argue the rating percentage for the PTSD, because let's be honest, if they're homeless, they shouldn't be rated 30% service connected for their PTSD. But in that situation, wartime veteran, no income, no net worth, VA is going to give them $1,400 a month. So hopefully they're not going to be homeless for long. It's not a lot of money, but it's enough to get some benefits started. In that event, the veteran files for and gets granted $1,000 a month for Social Security. They're 64 years old and they're eligible. So they're 67 years old and eligible, whatever. VA is going to basically take away that $1,000 that they're getting from another source, and they're going to kick in $413 to keep them at the threshold, because that's the minimum the VA says that they should live on a month. So if they're not getting it from one source, VA is going to kick in the difference to make sure they're meeting that minimum criteria. Next slide. Just some more examples that will you guys can refer back to, kind of, Social Security. If they're deemed housebound, that income goes up to the $1,900 a month or thereabouts. So the VA is going to kick in more money because they're paying out money. Surviving spouse needing to reside in a skilled nursing facility, a nursing home, I don't think I've run across anybody that can cover the cost of a nursing home on their own. Typical nursing homes right now are running between $9,000 and $10,000 a month. I've yet to meet anybody that has that kind of income. So next slide. Again, another example. Go ahead and go to the next slide. Okay, this is one I wanted to address because Brent is going to talk about the dependent and indemnity compensation program, and that is a service-connected cause of death benefit. Okay. For a recipient of the DIC program that is residing in a nursing home where their Social Security, their employment retirement, the DIC benefit, it doesn't cover the cost of the nursing home, and Medicaid has to step in. In that situation, okay, they're allowed to keep $50 of their Social Security for their personal needs, and the entire employment pension goes to paying the facility, and the entire DIC check goes to paying the facility. So at the end of the month, all of their Social Security but $50, all of their employer benefit retirement goes to the facility, all of the DIC payment goes to paying the facility. They wind up with $50 a month for their personal needs. If they are the surviving spouse of a wartime veteran eligible for the survivor's pension program, there is a sub-program, I guess you'd call it, as part of this pension program, where the surviving spouse, if they get switched over to the survivor's pension from the DIC program, then they would keep $90. In that example, hold on, let me backtrack. In that situation, all but $50 of their Social Security goes to paying the facility. They keep $50 for their personal needs. All of their retirement from their employment goes to paying the facility, and the VA steps out of it. They say, we're not going to pay you that DIC payment anymore, which increases the cost that Medicaid has to pay for the facility. But then the VA steps back in and says, do you remember that $50 that you received that you got to keep from your Social Security? We're going to add $90 to that. So you're going to have $140 a month for your personal needs. So DIC gets taken away. The survivor's pension steps in and offers a cash award that is only applicable when they are in a true nursing home in a Medicaid bed. But it's something that's important for you as representatives to know, that this is that glitch in the system where they actually benefit by giving up a benefit. So I think that is the end of my slide presentation, and I'm going to move this over to Brent Filbert, who's going to discuss in detail a little bit more the dependent and indemnity compensation benefit.
Hello, everybody. So I'm going to talk about what's known as DIC. I did want to answer the question that was posed about how to initiate representation before VA. And that's done using, like most things with VA, by using a form, which is for attorneys, it's the 2122A form that you would use to submit. It can also be used for other representatives as well. But you submit that to the VA, and then you become their POA or their rep before the VA. A couple things to keep in mind is VA will only recognize one representative at a time. So if somebody else is representing the veteran and you submit a 2122A, that will knock that person out of the representation, and VA will only recognize you as the rep. If your representation is ending for the veteran before the VA, the way to do that without somebody else submitting the 2122A is you just submit a letter to VA advising them that you are no longer the representative of the veteran, which, like a lot of things with VA, it can be fairly quick when they recognize that, or it can be an extremely long time. It's very confusing to me about why there's such an inconsistency and how long it takes. But those are the processes you would use in terms of representation before the VA. One thing real quick before we move on, there were a couple questions regarding pension. Eugene, did you answer those questions? They were in the Q&A.
I have not. I believe time was set aside after your program
Oh, okay, that's fine.
ask
That's perfectly fine.
questions for both.
Yeah, that's fine. Okay, all right. So let's go ahead and press on here. Next slide, please. So I'm going to be talking today about what's known as DIC, or dependency and indemnity compensation. This benefit is if you're practicing in veterans law or representing veterans before VA, it's a really important benefit for primarily surviving spouses, but sometimes it can also be for children, for sure, and in rare instances for parents. So the typical situation is that a veteran will pass away, and the question will be, is the surviving spouse going to receive this monthly compensation that's known as DIC, and also there are other benefits that go to it as well, but we'll just focus mostly on the compensation part of it today. But if that's going to happen, which can be extremely important for, as you can imagine, for a surviving spouse to get that monthly compensation for the rest of their lives. So we have a lot of those cases here in the Veterans Clinic. Sometimes they're very straightforward, and sometimes, like a situation where we're representing a veteran, they unfortunately pass away. It's clearly related to their death is clearly connected to their service-connected condition or conditions. We apply for DIC for the surviving spouse, and VA grants it. Other situations, it can be more complicated because the veteran will pass away, and it may not be clear based on, for example, the death certificate, if a service-connected condition was a cause or was a contributing cause to the cause of death. Or there could be a situation where a surviving spouse will come to us sometimes many years after a veteran has passed away and ask the question, is it possible to get DIC, looking back and then trying to service connect a condition and then have VA determine that condition to be the cause of death or a contributing cause of death. So there's different scenarios that come up with respect to DIC. But so just start with the basics, is that DIC is a monthly tax-free payment to a service member, surviving spouse, child, or parent. And those have particular definitions that we'll go through because of a service member's service-connected death. And when you look at what is a service-connected death, the statutory language is that it requires that it resulted from a disability incurred or aggravated in the line of duty in the active military, naval, air, or space service. And when you look at what is the active service, it's active duty for training, and inactive duty for training. So those are that's the basic statutory language for DIC. Now let's get into the sort of the nitty-gritty of it. Next slide, please. Okay. So under the statute, when we talk about the veteran's death resulted from a disability incurred or aggravated in active service, that it does not require, it does not require that the veteran receive service connection for that condition at the time of his or her death. It can be afterwards. It can also, it can occur afterwards, which I will explain. So the situations where DIC, where a surviving spouse, child, or parent would be entitled to DIC in terms of the death of the service member there are a couple of situations. One, if the veteran or service member passes away during active service, they die on active duty, then their death is going to be service connected, and DIC will be awarded to a surviving spouse, child, or parent. The situation, so we don't really see that situation here because it's usually very straightforward. Where we see these cases is where the veteran passes away, and the question is whether or not the death was due to a service-connected injury or disease. There can be a couple of situations where that occurs, where the service-connected condition directly caused the death of the veteran, and that would be a situation, for example, if let's say the veteran had non-Hodgkin's lymphoma, and then they pass away, and the death certificate says, and the non-Hodgkin's lymphoma is service-connected. Let's say it's a Vietnam veteran who was exposed to Agent Orange, or would have been presumed to have been exposed, and non-Hodgkin's lymphoma is a presumptive disease. And on the death certificate, it says that the cause of death was, the primary cause of death was non-Hodgkin's lymphoma. Very straightforward. VA is going to look at that, and they're going to award DIC to a surviving spouse. How the service connection occurred, I gave you a very straightforward situation. It can be direct service connection. We talked about, Katie talked earlier about the different theories of service connection. It can be direct, it can be secondary, or it can be presumptive. The non-Hodgkin lymphoma was a presumptive situation. It doesn't make any difference as long as there was a service-connected condition that caused the death. The second situation is where you have a service-connected disability, and it may not be the primary cause of death, but it was a condition which contributed substantially or materially to the death of the veteran. So I'll give you an example. A veteran had bladder cancer, which was not service connected. And when they passed away, the bladder cancer was identified as the primary cause of death. However, the veteran was diagnosed with diabetes, which was service connected. If the diabetes was a contributing factor to the death, in the sense that that condition can cause lots of other issues with the patient, and can contribute to somebody passing away more quickly. It can reduce the ability of someone to fight off a disease or condition. and so on and so forth. And so that situation I'm talking about is one case we actually had where the veteran, as I said, had bladder cancer, not service-connected. They did have diabetes that was service-connected. The death certificate just identified the bladder cancer as the cause of death, and did not really identify any contributing factors. And in Missouri, if you look at a death certificate, it'll have primary and really sort of secondary or contributing causes to the death. In that particular case, what we did is we went to the physician who signed off on the death certificate and asked, if the diabetes would have been a contributing factor to the death of the veteran. And the physician was like, yeah, he agreed that it was, in the sense of all the systemic problems it caused for the veteran, and it limited treatment. It also, in his view, reduced the ability of the veteran to in terms of being able to overcome the bladder cancer. So the physician was willing to amend the death certificate to add the diabetes as a contributing condition to the death of the veteran. And then we submitted that to VA, and they determined that that diabetes was a contributing factor, and therefore gave the surviving spouse DIC. That's how those cases can work among many other situations. Okay, next slide, please. Okay. Another situation where you can have the service-connected condition and DIC. Another situation where you don't need a service-connected condition is where you have a veteran who was awarded service-connected compensation for a particular period of time at 100%. So situation you most commonly see is a veteran who was 100% service-connected. That's a requirement. So their total disability, so they're 100%. That can also include TDIU as well to get to the 100%. For 10 years prior to their death, then the service-connected conditions don't need to be identified as contributing or the cause of death. It's just the amount of time and the level of the service connection. So that is another situation where a surviving spouse can get DIC. That time period of 10 years can be 5 years if the veteran was 100% service connected at the time of discharge from active duty. So once they were discharged, at the time they were discharged, it was already recognized that they were 100% disabled. Then they would be entitled to DIC, or the surviving spouse would be entitled to DIC as well. Now, a situation where you could, and the situation I'm talking about in the first bullet there is where it's clear that the veteran is service connected. VA has made that determination. So there's any question about that. You do have situations where you could go back and apply to VA to show that the veteran should have been service connected at 100% for 10 or 5 years, but for a clear and unmistakable error by VA on a claim that was filed during the veteran's lifetime. So VA just messed up, and you would go back and make the application asserting that the veteran should have been at 100% for these time periods. Final thing here is that the amount of DIC is increased if the veteran was married to the same spouse for at least 8 years prior to death. Then a higher rate of DIC is awarded under the statute. Okay, next slide, please. Okay, the question that will come up is who is a surviving spouse? We've seen a few of these cases at the Veterans Clinic. I did want to, before I moved on to the surviving spouse, I did want to also just talk about a situation where the service-connected disability isn't doesn't exist at the time of the veteran's death. So the actual VA has not determined that a condition was service-connected. It is also possible to apply for DIC and demonstrate that there was a service-connected condition at the time of the veteran's death. The veteran suffered from a condition that was related to their service, and that it was the cause or substantially contributed to the death of the veteran as well. That's another scenario that can come up that we have seen. We've had some recent cases where we've done that and succeeded. It can be kind of a long haul in that regard, but that is another situation as well. Okay, so let's talk about who is a surviving spouse. And under the statute, it provides that a surviving spouse is a person of the opposite sex, which isn't actually true anymore in terms of how it's interpreted, but that's what it says, who was the spouse of a veteran at the time of the veteran's death and who lived with the veteran continuously from the date of marriage to the date of the veteran's death, except when there's a separation due to misconduct or procured by the veteran without the fault of the spouse, and who has not remarried. And I'll get into the remarriage part of it as well. One typical situation is the surviving spouse is married to the veteran. They live together. The veteran passes away. That's a surviving spouse. You do have situations where the question of cohabitation will come up. The surviving spouse must have cohabitated with the veteran at the time of death. That is a requirement. It's not that they were continuously cohabitating during the entire marriage. There could be periods where there wasn't cohabitation for whatever reason. There obviously with military personnel and all kinds of reasons why that could happen. But that really, it's just cohabitation at the time of death. And if they're separated at the time of death, the surviving spouse could also still get DIC or be considered to be a surviving spouse if the separation wasn't the fault of the surviving spouse. And that situation that we have seen is where the veteran is doing something which is causing the separation. We do have cases where the veteran, has mental health issues, has addiction issues, and other behavioral issues, and that's what's caused the separation. And in that situation, their surviving spouse is not going to be penalized and not allowed to be considered a surviving spouse. So that's the first part of the requirement in terms of cohabitation and marriage prior to the death of the veteran. Now, after the death of the veteran, the surviving spouse, the general rule has been that the surviving spouse cannot have remarried. That's the general rule. That's kind of always been the rule with DIC. There's some changes to that as well. But there is also the requirement if the surviving spouse has not remarried, which would put her or him in a situation where they would be considered to be a surviving spouse. They also cannot not have lived with another person and held themselves out openly to the public to be the spouse of another person. So they can't have, after the death of the veteran, they can't have essentially acted as if they were married to somebody else and put that out in the public. Exactly how that information would get to VA, I'm not exactly sure, but that's the rule. Also, on the person of the opposite sex requirement, the way that's no longer true, and same-sex surviving spouses can receive DIC under VA's own interpretation of the statute and their own regulations. So that's the current state of that of that issue. Okay, next slide, please. All right. So in terms of the marriage to the veteran, the general rule is you have to have a valid marriage. And whether a marriage is valid, VA would look to the state where the marriage occurred, or when the VA claim for benefits arose. They would look at the state of that time, to determine whether or not the marriage is valid. There are situations where VA will deem the marriage to be valid. Is if you have, let's say, an invalid, what will be considered legally an invalid marriage, is the situation where that would occur, where VA would still look at it as being a marriage that's okay, would be as if the surviving spouse, for example, didn't know the state where they were living did not recognize common law marriages, didn't know that the veteran was still married to another person, or if they were not legally allowed to be married. As far as the marriage goes, and looking at whether or not a marriage is considered valid, the marriage must have occurred 1 year or more before the veteran's death. And as I mentioned, the claimant could be in a situation where they entered into the marriage without knowledge of the impediment. That's a requirement. They can't have known about it. And you can't really have a situation where there's another spouse who's really a legal spouse who's competing for the DIC claim. These situations that I'm describing there are fairly rare, but those are the rules that exist in terms of a valid marriage for DIC purposes. Okay, next slide, please. Now, the rules regarding remarriage have changed. So currently, and this slide really should be maybe a little bit different in the sense that the remarriage of a spouse currently before age 55 terminates DIC benefits. That's the current law. Prior to January 5th, 2021, it was 57. They dropped it to 55. So what that means is that if a surviving spouse is remarried, then after the age of 55, then they are entitled to DIC. So that doesn't end up making them ineligible. And these rules regarding age have changed over the years, but those are the two most current rules regarding marriage and eligibility for DIC. Okay, next slide, please. So this is the current rate of eligibility for DIC. The monthly rate right now is, the basic rate is $16.53 and if you have one of these cases and you have an intent to file, or you file and it's initially denied, or we have cases where it's denied and you have to do a supplemental claim, and then you have to maybe apply to BVA. The retro payment in these cases can be substantial if the case takes a long time, as you would imagine. It could sometimes, but that's the basic rate. The rule for 100% for situations where you have 10 years of 100% disabled prior to death and married, we have the 8-year rule. You get additional $351.02. And then for each eligible child under 18, there's a bump up as well. And then for housebound, for spouses, there's an additional increase. And then aid in attendance, you can see that amount as well. For DIC, you could see how this would be very important additional income for a surviving spouse, child, or parent. Okay, next slide, please. I did want to touch on, in addition to surviving spouses, which are the cases that we most commonly see, there are situations where a child could be eligible for DIC as well. And that the rules for that, for a child to be eligible, and that is a biological, adopted, or stepchild, is a person who is under the age of 18. Normally, there's an exception to that. They are not married, and I'm going a little bit out of order here, not married, and also they're not included in the surviving spouse's compensation. They're not added as part of the dependent for purposes of the surviving spouse's compensation. Now, that 18-year-old rule can go up to 23 if they're attending school, which typically would be if the child is going to college. So they take it up to what would normally be the graduation year or age for someone who's gone to college coming out of high school. So a child can also get DIC as well if they meet these criteria. And there also the other requirements for DIC are met as well that I described earlier. A parent can also get DIC as well. And these cases are fairly rare, but the rules regarding that are the parent can be a biological, adoptive, or foster parent of the veteran. And that can be one situation. It can also be a situation where there's a parental relationship before entry into service for the veteran. That also is a situation, and it can be father or mother who are in that situation, or both. And then there is, to be eligible for DIC in this situation, there is a income limit for the parent in terms of being able to receive DIC. Okay, next slide, please. Okay, how do you apply for DIC? It's pretty straightforward. There is a form, as with all things when you apply for DIC or for any kind of VA disability compensation. It's a 21P-534 for surviving spouse and child, and 535 for parent. Some important things to remember. If the form is filed within 1 year of the death of the veteran and DIC is granted, then the survivor's benefits will be backdated to the first month after death. So it would go all the way back to the month of death. If it's filed more than a year after death and then later granted, then the survivor's benefits will be backdated to when the claim was received. Also, one thing to keep in mind is a claim for death pension is considered a claim for DIC and accrued benefits, and vice versa. VA will look at all those issues together, or they should look at all those issues together. Sometimes they don't do that, but those are the basic rules regarding applying for DIC. Next slide, please. Okay, that's the down and dirty for DIC. So I see there are a couple of questions I think were directed towards Eugene, but any other questions? I'd be happy to answer them.
So regarding the two questions that were posted in the chat regarding pension programs, the first was that can the spouse of a decedent veteran who, while still alive, was not service connected, still receive a pension? And the answer is absolutely. The pension program is just based on wartime service, assets or net worth, and income. It is not related in any way. The veteran could have never applied for any benefits, let alone a service-connected disability or the pension program. But yet when they passed away, the surviving spouse, you could look at their eligibility for the survivor's pension program. So there's no criteria that needs to be followed that, the veteran had to have been in receipt of a benefit in order for the surviving spouse to be eligible for a benefit. That is not applicable in this case. And the second question in the realm of aid and attendance, does a veteran need to be spending 105% of their income on medical care expenses in order to qualify? I'm assuming this is kind of asking a question, will they qualify for the maximum benefit? Because of that mapper where the VA says that they should pay for 5% of their medical expenses, if their income and their medical expenses are equal, okay, basically if the threshold is the same as their income, what you're going to get is you're going to get that income reduced a little bit because of the medical expenses, but yet there's a little bit of medical expenses that doesn't get covered. So in theory, if you wanted to max out the benefits, okay, then yes, they would need to have medical expenses that equated to 105% of their income, simply because you're trying to reduce their income down not just to zero, but below zero because of that mapper. But when you factor in cases like nursing homes, assisted living facilities, in-home care, those types of things, you tend to not wind up squibbling over the little stuff because, those expenses are so intense, so great that it tends to wipe out their income anyway. So just one other statement in regards to the parents' DIC. It needs to be a service-connected death, but the program actually follows along the same lines as the pension program because it is income-based. They can use medical expenses to reduce their income, and get a higher award amount and stuff like that. So parents' DIC is a little tricky. That one never comes through well. So, but that's everything I have on those. Any other questions that we have for pension programs or DIC programs?
I see no more questions in the chat. I'll give you a couple seconds to finish typing if there's anything else. You can continue to type in the chat. I'm going to go ahead and do a quick plug of our pro bono network before we release a little bit ahead of schedule. So we at the Veterans Clinic have 6 staff attorney positions, and although we are the largest veterans clinic in the country, we can't take every case that comes by. We refer out to VSOs for any simple or initial claims, but there are quite a few cases that we see that are really viable, but we don't necessarily have the bandwidth to take. And the more outreach we do, the more word of mouth gets out, the more potential clients that we get. So we have a pro bono network program through which we refer out to partner attorneys in Missouri. And what we do for those is we'll do all the initial consultations for veterans and potential clients. We'll do all of the records collection, and then we'll write a brief memo about the case and the type of law that would apply. We send those out to attorneys who we think would be a good match for that, see if they have the bandwidth for it. And if they do, we send the veteran that way. We stay kind of involved in the process as much as the attorney would like. We're not necessarily looking over your shoulder, but if you need help on strategy or some preliminary issues that you don't understand in the record, we're always just a phone call away. And we have designated attorneys who will take certain types of cases that they are the expert in to kind of help our pro bono attorneys along if they have questions. And so far we have several large firms that are part of our program. We also have several individual attorneys who will just take 1 or 2 cases a year. If you think about our program, we've been going for over 10 years now. If even every single one of our alumni who came through the Veterans Clinic took one case, that would be hundreds of veterans that would get really good quality representation that we wouldn't necessarily be able to get to as a clinic. So if you are interested in the pro bono program, you can go ahead and reach out straight to me. We'll be sending out the slide deck from this presentation, and the recording from this presentation will be on our YouTube page for future reference. And my email will be attached to that send out. So feel free to reach out if you are interested in being part of our pro bono network, or if you would like to take on a client. You don't have to be accredited with the VA to take your first veteran client for a VA type of case. And so you can take one, see how it feels, work your way through it while you're waiting for the VA to come through with that accreditation, because they can take a little longer. Additionally, we have discharge upgrade cases which go through the DOW side, so you don't have to be accredited with the VA to take that type of case on. And there's a couple questions in here. A recently licensed attorney can take part in the pro bono program. You just have to have your bar in a state for the veterans, for the VA. Yes. So the great thing about veterans law being federal is that we do a lot of our work through Teams or Zoom. So you don't necessarily have to be co-located with a veteran to represent a veteran. And so you don't have to live in the area. A lot of our pro bono attorneys are in the bigger cities, St. Louis, Kansas City. So we don't work in person with them very often, but we facilitate Teams calls and phone calls. So it's certainly no problem to not be close by Columbia in order to be part of the pro bono network. And a lot of our veterans are very receptive to working with someone completely remotely. So a phone call, a Teams meeting has been really effective for us. And then I have a couple just admin things. Happy belated Veterans Day. This is the CLE program ID. This is worth 3 general CLE credits and fulfills the VA accreditation requirement. Like I said, we'll send out that slide deck. Brent, did you have any passing remarks?
I just wanted to thank everybody for attending and echo what Hannah had to say about participating in representing veterans on a pro bono basis. It is a great experience, and it's for attorneys who are looking for ways to make an impact outside of their individual practices. Representing a veteran is really a remarkable way to do it. So we need help because the demand for our work is really substantial, and just there are situations that are happen frequently where we just don't have the capacity to take on all the veterans who need our assistance. So we really would appreciate anybody stepping up and taking some of these cases. And you can do it now, you could do it in the future, but it really is important that we do that. So thank you from Mizzou, and everybody have a great rest of your day, and hopefully we'll hear from you soon. Thank you.